Welcome, everybody. We are here in Senate Economic Development, Housing and General Affairs. And it's Thursday, so it's Labor Day in this committee. And we're going to begin by addressing and hopefully getting to a place where we might even be able to vote on it, or at least be able to identify one or two issues that are still not perfect. We are going, I'm hoping that we might be able to get to a point on S-173 that we can vote it out. And I'll explain why with F-230 when we get to it, we may not be able to technically vote it out because of a glitch in our transference of bills from Senate Ed to Senate Economic Development, which hopefully will happen today on the floor. So without further ado, we welcome back our Legislative Counsel, Sophie Zadatny, to walk us through what is now a different version of 173.
So do I have permission to share my screen? The chair had requested just a summary for the bills that were out, so I'm just going to pass this around since they already.
Much appreciated. Yes. Oh, I think I've got one. Thanks.
Okay.
I printed that.
Everyone got one?
You sent it to us last night.
I did send it, but I made
Which I really appreciate it. Thanks.
So just to be clear, this is an amendment that it's not a strikeable amendment. So I just want to emphasize this still keeps what's in the original bill, which was the vocational rehabilitation changes to workers' compensation. So there were no changes to those. So section 1 continues as is in S-173. And then this includes some instances of changes. So it strikes out the mediator position and the Vermont Labor Relations Board, because originally the bill had vocational rehabilitation and then adding position.
A separate issue altogether.
Right. And
that's being addressed in the House. So that will come to us.
Well, it passed general and housing and it's in appropriation. So
it will come to us.
If it makes it out of appropriations and then it will be here. Right. So this amendment would strike out the existing section 2 and existing section 3, which dealt with appropriations. And then this would create a vocational rehabilitation working group. There's still a couple of gaps on this, but this was based on the discussion in front of the committee last time around that there needs to be sort of a revisit of how vocational rehabilitation is working for workers' compensation. So this would create a group. The group would basically need to meet by August 15th through December 15th, prepare a written report with any findings and recommendations for legislative action. It would be composed of 7 members. So it would have the Director of Workers' Compensation and Safety in the Department of Labor or their designee, and then 2 representatives on behalf of workers' compensation claimants. And the committee needs to decide who would be appointing these. 2 representatives on behalf of employers and workers' compensation insurance carriers, and 2 vocational rehabilitation counsellors currently certified in Vermont, who also need to be appointed by somebody. So there'd be 7 folks on the working group. And then the goal is that this working group would meet over the summer and fall to discuss and develop recommendations on how to improve the current vocational rehabilitation system and prepare recommendations for the General Assembly. And then there were specific questions for the working group to consider. And so there are 7 of them. What mechanisms could better identify which claimants are likely to require vocational rehabilitation services? Right now there's initial screening, and that's what the current language in the bill is looking to take away, that initial screening provision. 2, could utilization of vocational services be improved by enabling claimants access to vocational rehabilitation benefits while receiving wage replacement benefits? Again, there was a concern that by the time somebody's in a position to start receiving vocational rehabilitation, they've already exhausted their wage replacement benefits. So then they're not in a position to actually use the vocational rehabilitation services to which they're entitled. Could the workers' compensation system take into account the diminished earning capacity of those claimants who are unable to earn a pre-injury wage but are not eligible to receive permanent total disability benefits? should the average weekly wage be indexed to the cost of living for vocational rehabilitation purposes? What improvements could be made to ensure that vocational rehabilitation providers who provide services to workers' compensation claimants are familiar with Vermont's workers' compensation system? Again, there was some concern that the folks currently doing the initial screening are not that familiar with the workers' compensation system. Are some of the current requirements for providing vocational rehabilitation services too onerous and administratively unnecessary? And then how could the Department of Labor's oversight of vocational rehabilitation be improved? So those would be the 7 topics. Again, as I mentioned, the meetings would start August 14th, would have assistance from the Department of Labor, and then a report would be due by December 15th ahead of the next legislative session, with a report coming to this committee and then to the House Committee on Commerce and Economic Development. And then the working group would cease to exist once the report was submitted. And then currently it provides that compensation and reimbursement of expenses would be for up to 5 meetings and would be made out of monies appropriated to the Department of Labor. So the remainder of this provides that striking out section 3 again in the bill, originally section 3 was the appropriation for the mediator position.
Right.
And then includes that after the bill, if it passes, it be renamed as an act related to vocational rehabilitation, just to be clear on what the bill would actually do in its current form.
So before we begin discussion of this, I just really want to thank the Department of Labor and Kelly Massicott for coming together, and whoever else was involved in the offer and the acceptance of really working on this, instead of just picking 1 or 2 issues that we make a decision on in this committee, that we really look at it holistically. And looking at it holistically, thank you, Keisha. So thank you, Department of Labor. Thank you, Kelly, for coming together to really look at workers' comp, the vocational rehabilitation issue much more broadly and in depth, and coming to us with a recommendation for action for next year. So grateful to you for that work, and thank you for this. And what are people thinking? David Thomas.
Yeah, I'm inclined to support it. I'm just curious if Department of Labor has an opinion based on the changes, the most recent changes. It's kind of a stamp.
And we'll have to come and do that. I think for discussion, what we need to do is decide who's doing the appointing. And I think it probably has to be the governor for at least one of them. And then, maybe the governor or the speaker or the pro tem. I mean, those are the 3 I think that we're able to ask to appoint people.
Yeah, and the committee on committees for the
A committee. So,
I don't know if you can. I mean, you could maybe have recommendations come from.
Oh, that would happen, and I think people, at least in the House and the Senate, we get to, if we are following an issue, we get to say to the pro tem or the speaker, I would be really keen on serving on this. This is 173.
No, just the voc rehab working group.
Yeah.
2 people.
And I was just, when you came in, thanking Kelly and the department offered to help convene this conversation and really do it much more fully and holistically than we were addressing here. And I think,
as it's 2-2-2, I mean, it could be that
the governor
the
do one, the speaker do one, and the
well, but there's two
Yeah.
from each group. So
Yeah.
I was thinking maybe the speaker does like one vocational rehabilitation person, and the committee on committees does one, rather than the government. I don't know if the governor has to do one.
Then let's do that. That makes some sense.
And I can make that change.
So,
Great.
sure.
Yes,
So
Tom?
this keeps entirely section 1, which would eliminate the screening process.
Yeah, so there were no changes. I can pull that up.
So actually, Sophie, as we go forward on this, I think I'd rather do a strike all so that it isn't, I think a strike all is just easier for everyone to see and understand.
I know we've been encouraged, just so you know, been encouraged to not.
I was gonna say, I think
Oh,
we're
you're
getting too into the strike calls.
But really, they're much easier for us to
Well,
appreciate.
the secretary perhaps has a different viewpoint on that.
Well, he may, but he's not us. So,
But I'm happy to do that. Do you want me to? I can pull up the
Okay.
Introduced it, that would be helpful.
I had, I remember some pause on the screening, completely removing it because I just don't know, what value there is. I feel like there might be some value in adding that stat, that existing stat, where somebody has to at least look at it before it goes to the next more costly step. But maybe I just need to go through my notes to review what the estimates are and how many times these things do get referred.
Yeah, and maybe Kelly and Dirk can help us with that too.
Is it 100% of the time that the screener just goes, but it just takes longer? Is that what it is? Or there's still some times where the screener filters out requests for vocational rehabilitation when they genuinely just weren't warranted? That's what I don't recall.
I'm gonna let Kelly answer that, or who should answer that? Dirk. Go ahead.
Thank you, Madam Chair. Dirk Anderson, Department of Labor, Director of Workers' Compensation. My numbers are very rough, but the initial you want me to?
Sure, absolutely.
Um,
Sorry, I'm just trying to find, I know.
So I believe the last time I was here, I said that there were annually voc rehab screens about 150 claimants for voc rehab eligibility. Approximately 40% of those are not approved for voc rehab. The reasons for that are varied, but a lot of the times it's because the injured worker has not yet had a surgery that they're scheduled for, or they're recovering from the surgery, and they're still sort of in a place of flux where it's not really clear exactly what level of recovery they're going to be able to achieve.
That's really helpful. So if this were to go into effect, that 40% would not be, they would just directly go to voc rehab.
They,
That counts.
at 90 days, they would be, probably, correct me if I'm wrong, in 90 days, they would be referred, or they should be referred to a voc rehab counselor who would then have to perform an entitlement assessment. Right? What do we call it?
In theory, yes.
Yourself.
Sorry, Kelly Massacott with the Vermont Association for Justice. In theory, at 90 days, they would be referred to a VR counselor who would inquire of the person. Many people say, I'm not interested, to tell the truth, because they don't understand the benefit. And then it stops there. The VR counselor, if the person expresses interest, would meet with them. And I honestly think the screening in the statute is just a formalized step of what many of the VR counselors do, which is do a quick first blush, obviously entitled, obviously not entitled, hold. That really is the first step. And whether it's done at the screening level by a different state VR person who doesn't know comp and is not a good judge of those three categories, that's what we're trying to get rid of. Or a VR person in comp who does know those three categories and can make a better judgment. Obviously entitled, obviously not entitled, hold, right? Because of where they are in the medical process. So we're trying to get rid of this, what's kind of a formalized screening process with the state VR people, Weber and Dale, because it's not worked well. And so it's the VR people are doing the same kind of thing. They just know the requirements under comp a lot better. That's how I would phrase what's happening there.
Yeah, Thomas.
So the 40%, this is directed to, when they aren't approved, do you have a sense of how many of them never get voc rehab versus it's just a matter of a long period of time and then they get the voc rehab?
That I don't know. I do know that sometimes the screener will say, okay, you've got surgery coming up, or you're still recovering from surgery. Let's look at this again. 2 months or whatever. How many of those people fall off before they actually see a voc rehab counselor? I don't really know, but it would be some percentage stuff. I can say that, again, based on last year's statistics that I just displayed, there are annually voc rehab counselors perform over 200 entitlement screenings, which is more than the screenings performed by the the initial screeners. So some people are finding their way to voc rehab. You know,
But not everybody is part
either
of the challenge.
well, not everybody goes through the initial screening
Right.
process either. Some people go directly to voc rehab when it's to a counselor, when it's clear to both the claimant and their attorney and the carrier that these people would be good candidates for voc rehab.
I
know.
It does happen, but it's kind of rare. I see carriers use the stall tactic, frankly, of, oh, gotta do the screening. And it just puts off what is sometimes inevitable. It does happen, Dirk. I'm not saying it doesn't happen, but I've definitely had cases where it's pulling teeth because the official process is the screening.
To your point there, Madam Chair, my question is it a safe assumption to assume everybody should get voc rehab? If so, then sure, get rid of the screening. But if there are circumstances where voc rehab is not necessary, I just worry about putting more costs into a system. And that's where insurance companies, it's hard to defend insurance companies because they get a bad rap. They do provide some utility in controlling costs, both in the healthcare sphere and this.
Given that we're looking at the rest of these issues in this working group, would it make some sense just to add this, whether or not to keep the first screening in as one of the issues you discussed or not? Should we make that decision here?
In my opinion, I mean, if we go ahead, if you do a strike all and roll everything into the summer study, we're gonna be back here next year, simply where we are now.
No, we'll have much better recommendations from people who are all the stakeholders who are going to actually recommend specific
Yes,
action.
but as currently drafted, the bill does take action. It makes something happen. And I think, you know, you've heard the testimony, I tend to agree with it, that the initial screening is not really all that effective and that delays treatment. And I think the folks, Dale and our ability, yeah, would agree with that.
That was my understanding from your testimony, is that you agreed that the first screening could be dispensed with. That was what my note says.
That was my testimony. If committee wants to roll it into the study, we're gonna have to do the study anyway, so I mean, we can do it that way as well. I'm happy.
Jamie,
Jamie Fion on behalf of the American Property Casualty Insurance Association. You know, as the voice of the insurers would certainly support rolling this issue into an overall study. I think the conversation you're having this morning are a lot of the questions that could be asked. You know, what is driving the 40% number? What sort of questions are being asked in the screening process that either are on point or not? I think we're, you know, perhaps making some policy decisions in the vacuum without that information that you can get through the study. I think that we'll all be better informed.
Ellen.
I just want to repeat what I said in my earlier testimony, which is a voc rehab counselor from the comp system meeting or talking to an injured worker is not them getting voc rehab benefits. It's just them doing the screening instead of that Dale or Weber person. And yes, it may be a little bit more expensive per person. It's much better use of the carrier's dollars overall, I promise you, than the delay that results from the screening being done by Weber and Dale overall. Because the people who are really entitled to these benefits and substantial benefits perhaps are delayed greatly, as Karina Dunnigan, the earlier VR counselor who testified and gave that example of that gentleman. That's a real case. It was in my firm. Those people who are due those benefits and not identified early, those cases can be substantial, not just to in the amount of benefits due to them in the VR system, but to society and to the state of Vermont overall, because she testified, that guy pressured his doctor to release him early to go back to work on his feet, which is not medically indicated because he had no other choice. That's another conclave waiting to happen for another one of Jamie's clients. So the system overall is paying for that.
Right.
That person should have been identified a lot earlier. And if the screening, we'll call it screening, was done by somebody who actually knows the voc rehab system, comp system, which Dale and Weber people don't, they could have identified and said, get this guy into better training, education. He was dying to get back to work. And he could have gotten off TTD benefits, the wage replacement benefits earlier. And if he could have been identified by somebody who knows the comp system and VR rules, he would have been much better off. All of us would have been much better off. Jamie's clients would be much better off. So to me, this is a no-brainer to get rid of the screening folks. There's a lot of other things that can be improved, but this is a first step that makes all the sense in the world.
It actually sounds, oh, Tom,
My last comment on this is I'd love to know how other states do it. If we're getting out ahead of others where they don't have screening done by insurance companies, that would, if this is uncommon for us to have this screening.
well, the
that-
screening isn't,
We're not getting rid of screening. Sorry to talk out of turn. It's just not farming it out to people who don't know the rules about comp.
right, that's part of the problem. So and I don't know what other states do.
Nor do I.
And I'm not sure I'm not, in my mind, not thinking that that matters as much to me as the fact that it sounds like it's more efficient, saves time, and as people are screened first time by people who actually know the system, know how to save the insurer's money, know how to effectively get people back to work better, give better counseling. And with the Department of Labor recommending this, I actually am inclined to accept the bill as written. And we can always revisit it if it's not working, but if it's saving everybody money and time, that seems like a good choice to me. We're trying to make government more efficient and save all of us money, including insurance companies, and get people back to work. The whole objective of this is to get people the treatment they need, get back to work, get the training they need if they can't get back to work. That's what this, and so if this is more efficient, Department of Labor supports it. I tend to think I support the redraft of 173 comment. Randy and David, Keisha, how are you feeling?
I'm just waiting for the final nod, the Department of Labor representative, to see if he agrees with everything just articulated.
I would agree with that. From my perspective, I think it's beneficial to move ahead with removal of the initial screening and then, study the rest of the process.
Okay, terrific. And I would hope that in the course of that work that you have all graciously agreed to take on, if something else arose around this, that you would bring it back to us on this.
Yes, absolutely.
Right. Terrific. And this is, yeah.
Thank you, Madam Chair.
Yeah,
Ask
sure.
one
Yeah.
clarifying question.
And yeah. Sorry.
This may be a question for Sophie. The additional language about the study. Oh, yes, final line of subsection F, line 19, 18 and 19 on page 3 and 4. I just want to clarify. It says these payments shall be made from monies appropriated to the Department of Labor. I assume those are monies that have already been appropriated to the Department of Labor that we need to now
Right, so that,
find as opposed to an additional. Because that would, of course,
that's
send
right.
it to the month committee.
No, this is current.
Right, that's what yeah, I think that the expectation is that the department would find money, again, if the committee wanted to include an appropriation, then that.
No, this has no legislators on it, and so unless somebody is appointed, but it's highly unlikely unless we have an expert in this area. But I'm hoping it'll be stakeholders like Jamie and Kelly and Dirk and the people who live in Dale and the people who live and work in this system.
It does have travel reimbursement or and expenses. That's not a lot of money, sure.
No, it's pretty modest. And my guess is people may not even put in for those. I mean, as
Depends-
often is the case. You know.
Depends on the people, obviously.
So, but to go to who should do the appointing, the two representatives on behalf of the workers' comp claimants, should we do, that is we have 3 different sets of recommendations. Should we make them all 3, because there are 2 in each one, all appointed by the speaker and the or the committee on committees and and the speaker, and they would then each get 1 each? Can we clarify that?
That's what I understood you wanted.
Yeah, I think that makes sense.
That's fine.
Great, terrific, thank you. So, Keisha,
Madam Chair,
Rand, yes, Rand, Jane,
if I may, sorry, last minute. I just saw the language this morning. And then looking at the powers of the committee or the group, would this committee consider adding some power charge to at least look at the costs to the system that would be looked at as well?
Absolutely. If
I
we
don't
want,
see anything in here that looks at that.
Jamie, I think that's a good ask because at least I'm assuming in my vote that this is going to be a more efficient way of using our precious resources. So, and yours, and yours or ours. though.
Employers of the state.
And employers. So, how would we like to have Sophie add that? Yes, Kelly?
Is it not already contemplated in the charge? Sorry, let me bring up the language, which right at the beginning talks about, not just timely, but costs. I thought it did talk about costs.
It's Robert TV. What?
It doesn't have that in right now.
Oh, sorry.
It's about other money, okay, about other monies, but not that, what it might save the system, because I think that's an important question.
Line 14 on page 1, timely, in a timely and cost efficient or cost effective manner.
The needs of the eligible, on page 1.
Sorry, am I not on the right? No, hang on. I may be on the wrong. Am I on the earlier?
Well, that would work there.
The creation, yeah, sorry, line 14.
Yeah, it's on page 1. If
Line 14, needs of eligible injured workers in a timely and cost effective, because that's looking at the overall system, the benefits, the purpose of those benefits, and whether what the system is delivering.
I'm not going to split hairs over this. I'd rather it be a power charge. We all know when we get these groups that they look at what they're directly charged by the legislature. So
So I would suggest we do both add on line 14, add and cost effective, because that's what we're all hoping for. And then add a number 8 chart, or 7. We could add another one that referenced the how this would save, or how this would be more cost efficient to the whole system, or saving. I don't know. You're the drafting queen. I will look. That's a good cabaret act. Drafting queen. Sorry. We're always having to think about these things. Yes, Kelly.
Something about the insurance carrier employers dollar, I mean, I'm using,
Yeah, because that was
Sophie will use the right language, but their dollars being better spent to actually get the services injured workers are entitled to be better put to use, because I do feel like there is a lot of the burden administratively that these VR counselors.
how about reviewing the cost to the entire system?
Yes, something like that.
Oh, and that's what you already got, and we're only sitting 3 feet apart. Great.
And it does include in 6 about looking at whether the current requirements are too onerous and administratively
Right.
unnecessary. So I think
Exactly.
Or
well, I would just do it as a separate eight, but I did want to just flag that if there are ways to make it administratively simpler and more cost effective,
Right.
that would be part of it.
so,
I will do a slide
no,
more
I
and then
lost.
these changes and then adding in section 1, so it's a single.
Is that okay with the committee? Does that work? Okay. Having lost my agenda, a keeper of our time, what is
9:45.
to 9:45? So I would suggest that we go right in, if people are okay with this. David, Tom, are you okay with this?
Yeah, I have paused to know, and I'm guessing the House can take it up further, but I just want to validate a statement. I think I heard that this will save the money to the system. I worry that the screening, removing it actually might not do that. But if all of these people end up with voc rehab, sure, take it out of the stat. But if there are valid reasons to screen them away from a more costly voc rehab service, that's legitimate, then I do have those hesitations. But it's early enough in the system. I expect my colleagues in the House to take
Yeah, and I think
testimony on such a thing.
we can raise that with the committee
Yeah.
chair, that is a
Yeah.
concern for us to look at. I would, if we're all okay with that, and we might then ask Sophie to come and talk to us about 230, S230. And then if we can be efficient, speaking about being efficient about that discussion, perhaps you would be able to redraft so that we could maybe before 12 actually vote on 173.
Maybe before 10:30.
Oh, before, yeah, that's right, we have an hour. So sorry.
Probably see what I can.
I just said. Anyway,
Did you say
Okay.
an hour?
just, I said nothing too outrageous.
No, but we just need less than an hour.
Yes, I realized. So, maybe we will just return and vote this on this, either tomorrow or the next day, or on Tuesday. Great. So let's shift to S230, which has sort of become our miscellaneous labor bill. Thank you, Dirk, so much, and thank you for your offer. That was good, much appreciated.
I had a summary on this one as well. I don't know if everybody printed it out. or not.
S230, up, you sent it last night. And we have it printed for you, I think, at your place.
I do not have a.
S230.
For,
Here.
so if you want to pass one to him.
Yeah. Okay, great. So let's shift to S230, which is become,
So this is a strike all, and this would,
and the other one we would also like.
I would, yes, I would do that. So this, removes, what originally was in the bill, which was to do with the flexible work arrangement. So it deletes that language that would have required employees to grant requests for flexible work arrangements that are not inconsistent with business operations.
Right. And may I just say, I emailed the committee last night about this. I hope you all saw that. But I would say that we're taking this up in Senate Government Operations with the VSEA on the VSEA issue prospectively, using flexible work arrangements as a piece, as a bargain, and that they would be able to use it in their bargaining.
Yeah, it would be a mandatory subject for bargaining.
It would be a mandatory subject thing, but it would be prospective, so we wouldn't be, and my sense, so it wouldn't be interfering with the current contract, but it's prospective for future contract. What I heard around this committee, and correct me if I'm wrong, was that with one or two exceptions, that were the majority of the committee was not interested in moving ahead on mandating flexible work time for all employers.
Right, it was,
At this moment.
it would cover all private.
Right, so that was my sense about the majority, and so that is why we're gonna I just thought it made more efficient use of our time to give that to GovOps for the moment, and then when we have more time, consider flexible work arrangements for all employers in some less mandatory way, but perhaps with a carrot that would take us a little more time. Is that fair, committee? I just feel like I'm only talking today.
Yes, ma'am.
Thank you. Thomas,
Yeah, it's good.
Asia.
Mhm.
Yeah, okay. Okay, on that preface,
So we already have previously walked through section 1 and section 2, but section 1, this is adding in the full-time teachers, for their coverage under the Parental and Family Leave Act in Vermont by referencing the federal definition, under the Family Medical Leave Act. And this was, again, it underlines here the airline flight crew. They were added last year by that, code of federal regulations, and the teachers have asked to have the same language added for them. There was a question around how many other of these sort of special groups there are, and these are the ones. Didn't find any other sort of special categories. So I don't think you're gonna have a flood of other folks coming in
Sure.
on that.
yes, Tom.
So just to preface this question by saying I'm not volunteering to present this on the floor, but I would say, it's a good question that I think we should be able to answer before this goes. Is my understanding is this would not have any measurable way to impact on the ed fund because this is unpaid family leave.
Right.
Is that
This is
correct?
unpaid.
Okay. That is
And
correct.
yes, maybe we might ask.
So, thank you for volunteering.
No, I prefaced it.
Okay, so happily we explored, there were no other special categories, so we're not gonna.
Right, I don't-
Sure, yes. Okay, great.
Section 2, this was adding, so under Act 32, last session, safe leave, the definition of survivors of domestic violence, assault, sexual assault, stalking, was added to the Parental Family Leave Act. And so this was a request to add them to the definition of crime victim under the Fair Employment Practices Act, which is a sort of discrimination act. And so this is, again, we went through this last time, there was testimony on this, and then there were questions around the attestation part,
Yeah.
the documentation part. And again, this is essentially a cut and paste from what was passed in Act 32 under the Parental and Family Leave Act. So this is now in here, and then again, definitions to the existing code provisions. And then what's new to this committee that you haven't seen before is section 3. And this was language that was in a bill that passed out of the House and is currently in Senate Education. And what this does is it's just
Sorry, this, for those of you who were on the floor yesterday, this is when I stood up because Seth wasn't there during the announcement, so it didn't get moved. And education was gonna talk about it yesterday, and I'm hoping they agreed with Seth and me that they're gonna move it today at 1 o'clock.
it's essentially an issue under the Fair Employment Practices Act. It's really not an education issue. And what it is just cleaning up some language that's been unlawful for 30 plus years. So under the Age Discrimination and
Since
Employment Act,
1994.
it's 1994. So in 1986, at the Congress basically said you could no longer have mandatory retirement for university professors effective January 1, 1994. So there was quite a big gap there to sort of see if anyone came back and said, oh, this is a bad idea. No one did. So it went into effect January 1 of 1994. So since then, colleges and universities cannot force tenured faculty to retire by the age of 70. But we still have this provision in our Fair Employment Practices Act. And so it looks like it's still good law because it's on the books. And then even more troubling is that it's gotten sort of updated as technical corrections are made, you know, him, her.
No, we keep
You know,
investing in it.
Right. Well, it just keeps getting those sort of
And it's
things. So it looks like it's still in effect. And so it just seemed like maybe it was time to just take it off the books because it's been illegal for 30 plus years. So
Yeah.
all this would do is simply repeal that particular section of the Fair Employment Practices Act.
For those of us who do the technical corrections bill every year, this would be great to not have it.
Well, it's a substantive, you know, it's substantive enough. It's not a
substantive
comma
enough.
or in a, you know, semicolon or a, you know, stray word. It's substantive enough that it needed to.
So
We're
we've been
comfortable that no institution of higher education has been using this
for 30
Right.
years.
for 30 years.
Right.
Yeah.
So it's not, there's no likelihood of there being any practical problem that's
Right.
surfacing by virtue.
The challenge, if you do a legal search, it will come up. You know, if you do an AI search or a
Mhm.
legal search, it will come up as this is Vermont law, but it's right. It's illegal at the federal level. So, yeah,
Right.
Vermont.
And so our own, Holly is the one who put this bill in the House to clean it up. As the former dean of the law school, so.
Yeah, and it passed the House, but it just got sent over to Senate Education, and I know they've got a lot of things on their plate. So,
I know your husband, he just at UVM.
And he
so
was
it's
a-
motivated to keep it working,
did you
isn't
see
it?
that? Did you see the ticker there?
No,
Oh, he got interviewed by a UVM
Bizarre.
student about it because they figured he was the oldest person on campus, so they went to talk to him, and it did land up being a Digger article
I didn't see that.
about it. Yeah, so it was pretty funny.
But this isn't you trying to keep him working.
No, no, no.
No, I think this is clean up and it sort of fits into the labor bill, so we thought it might be a good addition. So,
Oh, and then it also, I just took it down, but it would also propose just changing the name of the bill if it passes, because right now
Yes.
it's about flexible work arrangements, and it would just change it to an act related to fair employment practices, because that would cover.
that's the umbrella under which all three of these pieces fit. Great, so, committee thoughts.
All leads, I'm okay with the bill with the exception of the self attestation. I didn't like the idea back when we were talking last year. We were talking about the parental and family leave act. Otherwise, I'm okay with it.
So, we have Charlie has joined us in the room. And how can we, Charlie, I think I'm just gonna call because I think there are a couple people that have that concern that's ongoing. It's somehow, I don't know why it doesn't bother me as much, but I appreciate that it's bothering a couple of you. So Charlie, would you be kind enough to join us and address that? Because often this, I don't know if it happens with other crimes. So would you be kind enough to share your thoughts on this?
Absolutely. Charlie Glusserman, I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. As far as the self-attestation piece, I would note that there are many areas in Vermont law and just across the country in these labor law situations where self-attestation is used as a form of documentation for survivors. The law in the unpaid job protected family and medical leave was amended last year to include that.
So it's
Have
already
not heard,
in our statute.
it's already in our statutes, for job protected unpaid leave. This is simply aligning the documentation standards. We have not heard any concerns since that law was implemented about the self-attestation piece. And that's something that we have really tried to keep an eye on. I would also note that this language was brought forward by the Civil Rights Unit in the Attorney General's office. I connected with them this morning to see if they had any numbers or anecdotal data about how status as a victim of crime is used in fair employment practices. Just because of the time, I haven't been able to hear back quite yet, but my understanding is that protection is not used that often. It is these very, very dire circumstances where an employer and an employee have a disagreement. Of course, that can still move forward with a lawsuit. And if that is the case, then a survivor or otherwise, an employee would have to justify that in court. And so I think those are the checks that we see to ensure that this documentation is used appropriately. That's, what I would say.
Whole issue could be hedged with filing the police report. The other, wherever they've reported it into the judicial system for their own protection, just use that. Self-attestation is, it's kind of like coming into school with a absentee slip that the kid themselves signed. It's just got the wrong route to it. And just because it's precedent from something we did last year, didn't agree with it last year.
The vast majority of survivors do not file a police report after they experience abuse. And so that type of documentation is not going to be available to them. Sometimes, as we noted in testimony previously, the need to seek relief can be quite timely. And even if they do eventually file a police report, maybe they get to a point where they feel safe doing that. It might be too late for them, and they might need relief earlier. These are adults, right? And so I think that there's a real difference in a child signing their own excuse from school, and an employee attesting that they are a victim of a crime.
Yeah, but then on page 3, line 4, section III, it's
Romanet.
there's a very easy out, very simple method to as opposed to self-attestation, is to have legal, clerical, medical, or other professional for whom the person has received counseling, et cetera, et cetera. That's pretty wide open too. And, I'm okay with that because they've at least had some validation. Again, I'm just trying to articulate a hesitation.
And I appreciate you sharing your thoughts on that. What I noted in my testimony last time was that what we are most afraid of is survivors falling through the crack between the documentation standards for job job protected unpaid leave and protections under the Fair Employment Practices Act. So, as it stands in law right now, a survivor could access unpaid sick leave and face repercussions. They could be fired by taking that leave because they don't have this kind of protection. And that would just be it would be really unfortunate for a survivor to experience the economic instability that would come with that and fall through those cracks.
Yeah.
So you don't believe that this paragraph III is enough protection for the employee that's has suffered in this way? That, I mean, the paragraph III here is just, it's pretty wide open. It's pretty liberal for at least somebody's validated that something happened. Isn't that a good compromise?
This is not the language that was passed in the unpaid job protected leave statute. And I think it's very important to align the documentation standards in those two statutes. I think it's very important that survivors decide what kinds of support they access. And I think putting survivor in a place where they would have to seek legal assistance or medical assistance or counseling when that might not be what they want to do, would be a disservice to them.
However, I mean, just to build, because we can have the AG come and discuss why they brought this forward and why they want this included. Is it after a sexual crime of this degree? Would not somebody naturally have talked to a nurse or been to an ER? Or, I mean, I know some don't. I know that a vast majority don't have police reports.
Mm-hmm.
But this net of professional contact in the course of experiencing something as horrific as a rape, would they not? One assumes that they would have a touch base with a professional. No.
This is a potential compromise. What if you took the self-attestation and just inserted the words under oath?
So,
Yeah, sure. That's a question.
I don't know. I mean, if Megan's here, I don't know how many employers we've talked to about the sensitive nature of this stuff, but I mean, I've employed people. I think if you have experience mentoring and or employing people, you really want them to feel they can trust coming to you with very sensitive details about a crisis that they're going through.
Unless you're the perpetrator of the crisis.
Well, right. And that gets to the a note from the parent or something. This is all kind of a little bit out of step with reality, I think. In fact, I mean, Charlie, maybe sometimes to her disappointment, has heard me say, and Jane Kitchell say, the more we ask people to prove, the harder it is to use this, but also the more expensive it is to administer. Most people don't want you to have to run your court paperwork up through HR and have 3 people approve it. They want to be able to support you through one of the most difficult things you might experience in your life without needing to pull out documentation. Like rape, which is probably one of the most underreported things. You want people to feel they don't have to bear the details of their life and their soul.
But they are.
To get help.
They're providing a document that says everything that's happening. And, you're not certain.
Your self-attestation could be a little bit more of what you're comfortable saying than, someone having to see some specific details in order to give you that lead. Most people are not making this up.
It says, right here, describing
I'd
certain
rather
cases
people vote
where
no
one
than
person's-
try and make us
One at a time.
ask for proof from people that has the potential to re-traumatize and re-victimize people. This is a best practice. I don't even think schools ask for
like permission slips necessarily anymore, because who's verifying that? I mean, really, you just want to know the child and you want to know that they're safe. You don't really want to like look to punish them or not. So this just feels really out of step with reality where we're going.
So, Randy, you had a thought too.
Well, I said under oath, but as just based on what we've been discussing a second ago, isn't that describing what happened? It says here, describing the circumstances supporting the person's status.
Yep.
And that means that that person is telling somebody
We want them to put their hand on a Bible or.
Well, no, are you saying it implies that they're sharing this information with others? They are,
yeah, they're sharing it.
Right, but they're sharing it in their own way. And I don't know what under oath does for that.
Under oath, it simply means a notarized document. So
Thomas.
So here where Grace coming from, maybe under oath, but as opposed to that, could this be interpreted, and maybe I'm looking at the lawyer here, as a verbal self-attestation, which could be quite, I don't know, worrisome in that you couldn't go refer back to it, like at bare minimum, or is the self-attestation having something in writing for the employers to lean on and to just hold in their HR files as to the rationale for justifying those leaves? Like, does this infer or imply that it would be a written self-attestation under oath or otherwise?
It does provide that it would be written because E at the bottom of page 4, it says a person is a survivor of domestic violence, sexual assault or stalking and by supporting documentation from any one of the following sources. And then it gets to the self-attestation.
Sorry, we don't. Page 4, and this is.
I don't know much, but if it's in writing, and it's a document that can be used in any, I don't know if we need to go to a Bible and under oath, but if it's gonna be in writing, that's something to hang the employers to hold them.
I mean, this is generally around discrimination claim, like someone would be claiming they were discriminated against because of their status as a victim of sexual assault, domestic violence or stalking.
And that they weren't given, remember, it all goes back to unpaid sick leave. So what, right? So
Well, no, what this is doing is adding it to the Fair Employment
Oh, this is
Practices Act,
adding-
which is the discrimination provision. So essentially, this is putting the employer on notice, right? Because if the employer doesn't know you're a victim of stuff, then any action the employer takes, whether that's adverse to the employee, it can't be based on their status as a crime victim. So again,
so they can't be discriminated against as a crime victim.
right. But again, so someone has a lot of absences because they're dealing with the aftermath of
Right, they could be docked.
right.
well, the
But
issue,
if they tell the employer, this is the reason why I'm having these absences and this is the documentation to support it, and then there's adverse employment action taken against them, then they could have a claim, a discrimination claim that it was against on the basis of their status as a victim.
and just from a clarity standpoint, supporting documentation. Does that mean that there is something in writing that supports the person's claim under the self-attestation paragraph?
Right.
Which would suggest there's something in writing. Now, does that something in writing mean that is the recording by the person to whom it's disclosed, documenting the disclosure, or does it mean something from the employee who's making a claim by providing something in writing?
I interpret it as the self-attestation being the employee is preparing a document that's then given to the employer.
My experience with employers I've had is they're very delicate, private proceedings and hearings where HR will talk with supervisors, and the written document is something where if there was a concern that somebody was maybe using this, I think that might be where you're coming from. It might be too easy for somebody to just say this in order to get this benefit. They could still press on the facts outlined in the self-attestation and ask for additional clarity. Does it give you any more?
No, I don't think they
said no.
That's self-attestation hearing.
They could
But that's sufficient.
Challenged.
Well, sure, it can be challenged, but the employee challenges back, saying, hey, look, it's here in writing that self-attestation is completely appropriate. Nothing else is required. And that's the end of that.
I mean, I think the cases in which that would be challenged is when there's reason to believe that self-attestation is not valid for some reason. And, you know, I think at the end of the line there, an employee would be in a position where they would have to defend that in court and it
Right.
would be up to the court to decide. I received a note from a friend, who just shared that since 2018, the Civil Rights Unit of the EGO, is aware of 20 to 30 matters involving, crime victim status as protected. So over the last eight years, 20 to 30 cases. And so these are protections that are very important for a very small number of people. And ensuring that it's accessible for that very small number of people is critical.
No argument. Yeah, that's not the point. The point is what from the employer's perspective, what's sufficient to warrant the absentee. That's all. And so very clearly, I think you've got, paragraph I is pretty heavy. That's, the formal law enforcement validation. Double I is similar, but a little lower in severity as far as requirements. Triple I is, it's pretty wide open. I mean, that's pretty, but 4 IB, paragraph IB, it's just, I think a little too. Look, that's all. You guys can disagree.
Thomas.
Here, so I think I heard you say, and this is where I want to validate that the employer could challenge this. I mean, they could also challenge 3, right? Triple I.
Yeah.
I mean,
They can challenge anything.
The employer could challenge the whole thing because
so I'll say as a faculty member, and this is not comparable in any ways, but I've had students that have provided documentation for missing exams before from other professionals where I said, this is a career counselor that doesn't have an official post somewhere. It's just your cousin that wrote you a note. So I don't mean to make light of the context of this, but all of these are contestable by the employer to validate those things.
Yes, that's absolutely right. And I do think that if there are questions about this piece, that maybe it would be clarifying to hear from the Civil Rights Unit of the Attorney General's office, who really has a more in-depth knowledge of these cases, but that's absolutely correct.
The employer is questioning the validity of any of the legal, clerical, medical, or other professional documentation or the self-attestation. They still have within their rights, their internal processes to collect more information, to hear from the employees, and to press on any absence of fact or absence of clarity. That'd be a fair statement. This doesn't prohibit the employers from pursuing.
No, so we have somebody who represents employers behind Charlie, who may or may not, we don't want to put you on the spot, but you're quick on your feet. So I figure that we could at least ask him, and you don't know Charlie, but Megan Sullivan for the chamber, would you be interested in weighing in, or do you have anything to add to this conversation?
Megan Sullivan, Vermont Chamber of Commerce. I will admit that I am looking at this language newly, and was expecting to be coming here looking at flexible work arrangement language. So I'm jumping in here with everyone else. I think as I'm looking at this language, I hear the certain concerns about self-attestation, and I think we have would be able to talk to members who I can't think of anyone in our membership who does not want to support their employees through incredibly challenging times. I can also think of a lot of members who have had challenges with abuses of leave and how that works. I think, one question that has come to my mind here is this just a requirement of survivors, or could the roommate who is also allowed to take time self-attest? Right. So if all the people who are allowed to take time to support a survivor, which is a pretty broad list of people, or do they?
This is just to clarify that
I would
that
appreciate
was
that.
under the parental and family.
I think we already did that.
Right. So that
this is
So
under-
that self-attestation is not
Just for the
applied
survivor.
to
right.
Yes.
the
No one else.
wide range. It is. I mean, I think I probably need a little bit more time to take this to members, but I very much see the concern of a self-attestation and how that gets viewed, and what if a self-attestation is allowed in law, what is the recourse?
It's already what you came in
Right,
after, but
I
it's
did, I'm
already
sorry.
don't be sorry. It's already in statute,
Right,
under the work
yeah,
we did
and I
last
remember
year.
that from last year, that was,
Right, and so this, aligns with statute already. So that's the request from the AGs that we
Right.
move this forward and align our statutes. Well, at the request of the AG and the network.
Right.
Thoughts?
I'm not, oh, sorry, I'm
So-
not sure I can speak really well at this point without having done,
Yeah.
more digging in, but I appreciate the concerns that are raised in the
Perhaps
conversation.
Find out, if you actually have had any employers where this was actually an issue. That would be helpful. I mean, because if it's current law, it's already a possibility of an issue that people have used a self-attestation. But as Charlie said, probably, I think after you arrived, there are only, since 2018, there have only been 20 or 30 cases that have involved this, a self-attestation.
Just to be clear, when you say crime victim status, it wouldn't be, it's not, that would be
All
crime
crime
victim status. This is adding, victims of sexual assault, stalking, the domestic violence to the definition of crime status. So this is, I mean, so again, maybe some of those were, sexual assault victims, but crime victim on page 2, like those are all the current folks that are covered by crime victim status under the Fair Practices Act. So it's not, that number of cases is not limited to sexual violence.
Oh, okay. I misunderstood that.
Yeah, so any victim of crime in Vermont who has claimed that status as a protected status in an employment matter, 20 to 30 cases over the last 8 years.
Sorry, say that, my brain had gone elsewhere. Could you say that one again? What's the qualifier since 2018?
Since 2018, there have been 20 to 30 cases of a victim of crime claiming that protected status in a fair employment matter. So, looking at the current law here, that could be a survivor of domestic violence, sexual violence, or stalking who had the documentation currently in the statute. It could be any other crime victim that is identified in an affidavit filed by law enforcement. And so that is a much larger group of people than just survivors of domestic violence, sexual violence, and stalking, who are currently right now they are eligible for crime victim status. It is just aligning the documentation requirements.
Okay. Thomas, do you have any further thoughts? Okay, I think so.
I don't know, I've been waiting in, but on page, if we go to page 2 of draft number 2.1, then on the qualifier in E at the end, line 17 through 19, might it to some of your concerns, Senator Weeks, which I think are quite valid, that this could be exploited if it's too wide open. I don't think anybody's going to, but regardless, what if it was, say, a person who is a survivor of domestic violence, sexual assault, or stalking, and who has provided supporting documentation for review from any one of the following sources with a for review. That's not saying yay, nay, but just making clear that the employer will review these documents and conformance with any other HR policies that they go through to make sure all the T's are crossed and then I's are dotted to line up their qualified, paid, unpaid.
Well, it's a good compromise, but that's not really the intent of it. The goal is to provide the necessary protections for folks that have suffered a domestic abuse.
Awful experience.
So, I mean, just giving it for review, I get it. I get where you're coming from. That
Just
doesn't provide that. It's too.
Charlie.
Just one thing that I wanted to note in case it is helpful reference. I was just kind of pulling up the full Employment Practices Act statute here. And there are other categories within the Fair Employment Practices Act where you can use self-attestation as evidence.
Which of those?
Religion and sexual orientation. And so, recognizing that there haven't been, challenges with that documentation requirement for those statuses, perhaps that would be helpful for the committee to consider.
So the additional self-attestation allowances in the Fair Employment Practices Act is one can self-attest with religious discrimination and with sexual orientation discrimination. And we don't, again, we'd have to ask the AG, but I don't know. I doubt we see too much abuse of that.
I think it would be a great question for them.
Yeah. Ha ha ha. Thank you, Todd, for listening. The AG's office has had their ears on our committee. And is she available now?
I believe so. I believe she can come.
Could we Zoom her in, Todd? This is like so 21st
incredible.
century that I can ask the full box to see if we could Zoom in. So it looks like the AG may be available now. Emily Adams is the Assistant Attorney General in the Civil Rights Unit. And if she could Zoom in now, that would be great. Thank you, Todd. I mean, it's always you wonder who's watching, who's listening.
Does this make the legislature more productive now that we have Zoom? Like, is this getting things to move faster?
I think it's
Compared
in
to-
this particular, if she's actually available, that will be sort of amazing.
Assuming that that's her is answering the phone.
Well, that's true. She'd have to self-attest to the fact that she is in fact Emily Adams. But then we're about to see her appear, hopefully.
In the olden days, we probably have to line her up. Send a
And
baby.
that's the Zoom
That's what
Todd,
we're coming
that
next
should be
week.
tracked.
Okay, we've sent the Zoom to Todd, and it would be great if Emily was available. That would be great. Well, that's helpful to see that self-attestation is used elsewhere. I think that's helpful. So we shall see. And if not, if it would help David, if Emily's not available right now, we can make some time for it next Thursday morning and try and vote it out after that. Either way.
Either way.
Okay, great. So we're gonna give it a beat. And any other thoughts? Is everybody okay with the first two sections? The teachers and the teachers and then the teachers
And the repeal.
and the repeal. Where is the repeal? Oh, the repeal is section 3. All right, is everybody okay with sections 1 and 3? David?
Fundamentally, I'm okay with it. I fully understand why airline flight crews are mentioned specifically. Teachers, on the other hand, I don't really understand why it's a call out, but I'm not gonna push against it.
I'm fine. If they're the
Everybody
other
can line
two,
up and get their name put into the paragraph.
if they're the other two special categories that are called out in
I get that. I still
elsewhere.
understand. Again, I'm not gonna push against a federal issue, but I don't understand why they're called out uniquely either. For time management.
any,
Said she will be joining shortly.
oh, great.
Yep.
So she's got the Zoom link. Great. We're gonna, this is, Tom, I think let's make us more efficient. We have 15 more minutes to,
We quantify that if we got more legislative legislation passed, as we've introduced soon. So it might be some previous.
Well, we've been able to have,
Is that good?
we've been able to have quorums when we couldn't have quorums before. We have been able to hear testimony from people all over the world, which has been incredible, which we could not have had before, right? We've had on some of our conversations, we've had people from the West Coast at different times. We've had witnesses from all over the place. Emily Adams, welcome.
Good morning. Thank you. Emily Adams, Vermont Attorney General's Office, Civil Rights Unit. Can you hear me?
Thank you very much for joining us. I assume Todd has filled you in on the subject that we're discussing.
Yes, he has, and I've been listening in myself. So thank you. Would you like me to just start talking? Do you have specific questions?
I think David Weeks can probably share his concern, and that is the concern we're trying to address. And We understand there are two other categories that are allowed to self-attest. One being religious discrimination and the other being sexual orientation, and we would be adding this crime victim as a third. And David really could frame his concern.
Well, I think she's been, so
If you've been listening, you know what David's
I've
concern.
been listening, yes, thank you. And so I think where I would like to start with this is just to clarify the reason for an interest in having this definitional alignment. So back in 2018, crime victim was added to the Vermont Fair Employment Practices Act as a protected category. And what that simply means is that an employer cannot take an adverse action, fire or discipline someone because of their crime victim status. So because of that reason. But the definition of crime victim in 2018 was limited in a very narrow way. And some of you may have been on this committee at that time. I think Kara Cookson was a large advocate for that definition. And that involved only statutory references to essentially being in a police affidavit or a court document saying you were a victim. And so since 2018 and prior to the leave bill last year, the only protections in Vermont employment discrimination laws were that, not taking an adverse action against an employer if they were a crime victim in a particular court document or police record. And we operated here in the Civil Rights Unit. We investigate allegations of employment discrimination, and we operated using that existing definition. Last year, 2 years ago, forgive me, I don't remember exactly which it was, the changes to the leave law were passed. Those changes expanded leave for victims of crime, including victims of intimate partner violence and domestic violence. And the definition, which you see in front of you, was placed in those leave laws. That is a different law than the employment discrimination protections. That is a law providing job protected leave. And so because of that, I'm not going to pass judgment on that definition that was placed in the leave laws, but the reason for seeking this alignment of definitions is we now have a structure where two laws within our enforcement that several of individuals may seek to utilize the protections of have two different definitions. So an employee who is a victim of domestic partner sexual violence may be able to take leave under the existing leave law structure for the reasons set forth in that bill, to seek housing, to go to court appearances, et cetera, to seek mental health treatment. But they are not, if they have not gone to law enforcement, if they are not indicated in a law enforcement document, essentially, they are not necessarily protected under that crime victim definition under the Vermont Fair Employment Practices Act. Where we have seen this arise is in cases where perhaps someone, and this is anecdotal, but we have had folks calling our office with scenarios like this, where someone goes to the employer and says, I don't need anything from you right now, but I want to let you know that my spouse and I are separating. I've been the victim of domestic violence. I'm working to get out of the house and get my children out of the situation. And then perhaps the employer fires them for whatever reason it may be related to that. Sometimes it's because the spouse also works for the employer and they don't want that drama in the workplace. We've heard that anecdotally. But if that person hasn't gone to law enforcement, they don't have recourse under the law for simply the firing, but they are currently protected under the leave laws. So it's been this funky definitional disparity that we thought, since we already have this definition in the leave laws, it would make sense to bring it into the Fair Employment Practices Act for protections. Because we do know anecdotally that many of these individuals, and Charlie can speak, I think, probably better to this, do not access law enforcement for a variety of reasons specific to their scenario in a domestic violence or intimate partner violence situation. So that's point one in terms of aligning the definitions. Point two, I'd like to address your comment on self-attestation and other protected categories. I would frame that a little differently. I would just say that the Fair Employment Practices Act has a variety of protected categories set forth. So that's race, color, religion, national origin, sex, sexual orientation, gender identity, ancestry, place of birth, age, crime victim status, or physical or mental condition, which is more commonly known as disability. under the law, someone can still have a claim for discrimination, say based on their religion or their sexual orientation. They're not required to have shown proof of that to the employer prior to their claim being brought, right? So if someone wants to say, hey, my employer fired me because I'm gay, there's nothing in the law that requires them to have previously attested to that. So it's not that the law has self-attestation in it, in its existing form. It's just that it's not required. Of course, in the course of any investigation, any court case under these laws, there would be discussion about whether the employer had knowledge and whether that knowledge was the basis for their adverse employment decision, because that's how you would prove a discrimination claim. But the concept of self-attestation, I think, is a little bit of a red herring here in terms of the discrimination laws as they currently exist.
Tom,
Is that helpful?
that was very helpful. Thank you.
Incredibly helpful. So in the conversation that I think you said you might have been listening to, I'm kind of curious with these 4 ways to qualify, for lack of a better term, the employer still has some obligation or right to review the documents and to hold internal delicate HR proceedings where they could look at the attestation. If there was concerns that it might not necessarily be as legitimate as I know it's a loaded word, but if they had concerns that they were that there was somehow exploiting the opening for self-attestation to protect their work employment, they still do have the right to review and overlay any claims in the self-attestation with what they understand about overall work performance. Or do they just have to accept outright they've self-attested, so I can't do this?
So again, we're in the context of the Fair Employment Practices Act, which is about discrimination. So I can't do this isn't really coming into the equation. The analysis is if someone is bringing a claim later on that they were subjected to discrimination or harassment in the workplace because they are a crime victim, it's about whether the employer had knowledge of that. And so right now in the current framework, an employer could fire someone who is a victim of domestic violence lawfully if that person doesn't have proof that they went to law enforcement to show that. This change would simply be that if an employer still makes that decision based on their victim status, that employee, the victim, may have recourse even if they didn't go to law enforcement. But in terms of, and of course, the evidence of whether someone made a good faith, is actually like any sort of investigation or court hearing would look at all the evidence in front of them and look at what the employer truly based their decision on. So if there is I think you referenced performance issues and the employer says, I didn't fire them because they were a crime victim, I fired them because of their ongoing performance issues, that is part of the legal analysis that comes into either any investigation by our office or any judicial proceeding on a court case that may come into play in this type of scenario.
The employer would still have the right to still terminate even with that self-attestation. They just run the risk of losing in court if they can't stand on the facts or on their reasoning for why they're terminating.
Correct. They would have to prove their own lawful reason for any termination.
Thank you.
Well, if the termination was on the basis of the person lying about the reason, in this case, alleging that there was a sexual assault or something of that nature, and the employer believes that that is a lie and has a basis for believing that, I'm assuming the employer could then discharge. Is that correct?
So again, that would be kind of an evidentiary issue that would arise down the road. I would encourage that employer to consult with their counsel about, their decision-making and their proof of the lie. But that scenario, I think, again, if it's a lawful reason, not based on the status, but based on the actions of lying or fabricating, could be considered lawful, yes.
And if the self-attestation, if the self-attestation was very vague, like it just quite simply had like one sentence, that doesn't necessarily bode well for the employee if the employer still chooses to override that. So the employer could still weigh on its merits the self-attestation. If it lacks specificity or detail, can they ask for more detail as to justify the
So again, I guess I'm confused in the context we're talking about where this would come into play. And so I'm going to use a different example again in terms of perhaps, so the cases we're talking about, again, are cases where an employee is fired, for instance, and then they say, I think my employer did that because I told them or I was a crime victim in some way, or because of concerns around me being a crime victim. If an employer is getting into the weeds on the validity of a self-attestation, I guess I'm not really understanding where that scenario is going to come up in the discrimination context. I do understand in the leave context, which is not the issue on the table, where you may need to get further specifics on what the employee needs and what the status is for the purposes of leave. We aren't in that context right now, though, so I'm not sure I'm understanding the question as it aligns with the current statutory framework.
So, Randy, and then we have to wind up in 3 minutes. So, Randy.
Let's say you're talking about working conditions and the employee says that I need to work remotely. I need to work at home as opposed to coming into the office because I've been a victim of sexual harassment and stalking and so on, and I do not feel safe coming into the office. Now, that would be something that would fall, I would think, within the confines of what we're talking about. And it's simply the self-attestation that the employee, for example, how does the employer know or have any idea of whether or not the employees are telling the truth?
So that actually is not directly within the FEPA statute. Again, crime victim is a protected category. If we're talking, certainly knowledge of someone being in a protected category is one thing, but if we're talking about what they're requesting in terms of a flexible working arrangement or accommodations, those fall under different protections and statutes. That is the flexible working arrangement law. That is potentially the Parental and Family Leave Act statute, which this definition has already been changed in, that does have intermittent leave in some circumstances. And then disability law has accommodations requirements in it, reasonable accommodations requirements. Those require proof that an employer has a disability in order to accommodate them. Nothing in simply adding this as a protected category.
It's already a protected category.
Would per se say that you then have to accommodate that employer. Again, it's about shall not, and I can pull up the statutory language, but it is.
You know what, Emily? I think we're going to have to return to this because we're due on the floor in 6 minutes.
Okay.
So we're actually go on the floor in like 2 minutes. Thank you so much for making yourself available.
Of course.
We'll have committee discussion about whether and we'll be taking it up again probably next Thursday with the hope to vote it out. But I think if David still has additional questions, we may ask you back in next Thursday morning. So
okay. Well, thank you very much for having me on short notice.
Well, we are so grateful for being available on short notice, and thank you, Todd. So with that, I'm gonna go off. We'll see you all tomorrow, and